Good evening and welcome everyone to tonight's event. My name's Mark Elliott, and along with my colleague Professor Alison Young, I'm one of the academic leads for the Faculty of Law's Constitutional Law Matters project. The aim of that project is to stimulate public debate and to enhance public understanding about the UK Constitution. And it's with those objectives in mind that our event this evening takes place, the theme of which is the role of the judiciary in the UK Constitution. To coincide with this event, over the coming days, we'll be publishing on our website, constitutionallawmatters.org, a series of video explainers looking at controversial constitutional law cases that raise questions about the court's role. And I'm sure that we'll hear about many of those cases this evening. So it's a pleasure to introduce our speakers and our chair. Our speakers are Baroness Hale of Richmond, who among her many distinctions is former President of the United Kingdom Supreme Court, Professor Anand Menon, Professor of European Politics and Foreign Affairs at King's College London, and the Director of the UK in a Changing Europe. And thirdly, Professor Alison Young, the Sir David Williams Professor of Public Law at the University of Cambridge and legal advisor to the House of Lords Constitution Committee. Our chair this evening, to whom I'll hand over now, is Professor Kate O'Regan, Director of the Bonavero Institute of Human Rights at the University of Oxford and former judge of the South African Constitutional Court. So thank you to all our speakers, and over to Professor O'Regan.
Thanks very much indeed, Professor Elliott. It's a great pleasure, and thanks to you and to Professor Young for inviting me to chair this important conversation. Constitutions really belong to the people, and it's very important, therefore, that we should all know about them and discuss them. And I think the purpose with which constitutional law, or purpose for which constitutional law matters, has been established to ensure that these issues around constitutional law are debated broadly within the United Kingdom is a very important one. And I can think of no better a panel than the panel we've got today to talk about the question of the role of the judiciary within the United Kingdom Constitution. The program for this evening is that we're going to start with each of the speakers speaking briefly on the topic. They have each made short videos, which you'll be able to access on the Constitutional Law Matters website if you look for them, but they're going to just give a succinct version of what they've said in those videos today. And then we're going to have a facilitated conversation between them before we turn to question and answer. You'll find the question and answer button at the foot of your screen on the right-hand side. Please feel free to put questions into the question and answer as we're going along. It's something I can pick up in the discussion, but we will also turn to them specifically towards the end. So please feel free to put it into the question and answer session at any stage. And if you wish, indicate to whom the question should be directed, or if it's to the panel more broadly. So the order in which our panelists are going to speak are first Professor Young, then Lady Hale, and then Professor Menon. And so I'm going to turn over now to Professor Young. Thank you.
Thank you very much, Professor. Thank you for that very generous introduction. I will try and be brief and look at two things in my video. The first was to think about what we mean by judicial activism, because there's lots of accusations of judicial activism recently, and I was trying to think about what I mean. Judicial involved in and just be dealing with law. So that's the thing I was trying to think about. But what I want to focus on more is this idea of having balance, which was the second that ran my video. So
I'm just going to interrupt you because your sound seems to be breaking up as you're going along, and I'm just wondering if you could either reset your microphone. Sometimes it can be when you've got earpods in. It's not completely broken, but it's just breaking a little bit. And I'm just wondering, maybe if you take those out and let's see if it might be a little bit better.
So what I was trying to do in my video was to try and look a little bit about what we mean about the distinction between law and politics, because the accusation is that the judiciary are being activists by taking political decisions rather than legal decisions. And I'm hoping that some of that distinction will come out in our questions and our discussions later on. So what I want to focus on now just briefly is the second idea I discussed, which is this idea of having a constitutional balance. So this idea of thinking about how do we get a good balance between the government, parliament, and the courts. And what I was trying to build on was the different ways in which these institutions take decisions and when it's legitimate for them to take decisions. So we see Parliament as being legitimate because we have elected MPs. So when we're thinking about taking complex policy choices, then it's much more legitimate for those to be made by Parliament than it is for them to be made by the courts. But when we're thinking about the role of the courts, we have to recognise that the court is independent. We have a strong protection of judicial independence in the UK. And so that means that when the courts are dealing with decisions between individuals and the government, then we have an idea of knowing that justice is being done and that justice is also being seen to be done, because we know that the judiciary are not meant to be taking these choices by looking at policy, but by looking at law. But I recognise that that is not always an easy line to make. And so I understand where some of these criticisms come from. But I think we also have to recognise that there's something else the judiciary are good at that can help them get a good constitutional balance. And that's because we see Parliament as weighing up all sorts of different viewpoints from different individuals. But sometimes a policy choice that looks good generally might in its specific application not actually achieve that outcome when applied to a particular individual. And the courts can be really good at pointing that out. Sometimes we don't get full representation, perhaps, of some minority groups in Parliament. So courts can be really good at recognising when general policies might discriminate against protected groups and be able to get that balance right by drawing to Parliament's attention that a particular policy choice hasn't necessarily worked for a particular individual or has created discrimination in its application to a particular protected group. I think another aspect of this constitutional balance is the courts being able to point out to Parliament when choices that they make might undermine long-standing constitutional principles. And I think when we have a system of parliamentary sovereignty, where we don't have a written codified constitution with a constitutional account of the role of the courts or these legally protected constitutional principles, we still need the courts acting as a constitutional backstop to be able to point out when political choices harm these long-standing constitutional principles and require Parliament to look again to make sure that their decisions don't undermine these principles. So that's what I mean by constitutional balance. And that's why I don't think the judiciary are necessarily being active or being activist when they're taking these decisions and putting checks sometimes on the government's actions.
Thanks very much indeed, Professor Young. And now I'm going to turn to Lady Hale to give us a brief summary of her video. Lady Hale.
And it's good to be with you all. Well, following on from what Professor Young has been saying, we do have a constitutional principle of the sovereignty of Parliament, but we also have a constitutional principle of the rule of law. And the essential feature of the rule of law is that it applies to everyone. Obviously, the people and businesses and enterprises and organizations who are governed by the government, but also the ministers and officials who are government. They too are subject to the rule of law. And there are a number of processes whereby actions of public authorities, ministers, government officials can be challenged in the courts. Judicial review is one of them, but there are other processes as well. And there's been a huge increase in the use of these processes over the last 50 years for a variety of reasons, one of which is the hugely increased scope of government and its activities, tentacles in all corners of our lives. And of course, the use of judicial review is not particularly popular amongst the people who are being reviewed. This is not surprising. I don't believe that ministers, government, public officials set out to do things that are unlawful, quite the reverse. And of course, if it turns out that what they have done is unlawful, well, then it's not very popular with them. And it can be extremely costly, inconvenient, and can delay matters to have to respond to a challenge by judicial review or whatever process that is. And it can be all of those things, even if it ultimately fails. So I'm not surprised that government is not too keen on judicial review, etc. I think that's particularly true of politicians rather than officials, because politicians are elected to do things and they want to do them. They want to get them done. This is not surprising. And if judicial review gets in the way of them getting them done, well, then they're inclined not to like it. And I also acknowledge that courts are not perfect. They don't always get things right. They don't always get quite right the dividing line between the legality of what a public authority has done and the pros and cons, the merits of what that authority has done, because it's not always an easy dividing line to draw. But I do believe that they do their best to draw it properly, and it's only because nobody is perfect that they don't always get it right. And of course, I would say that, wouldn't I, having been a judge for a very long time and having spent rather a lot of my time in recent years on constitutional law and judicial review. But the independent reviews which the government itself set up, both of administrative law and of the Human Rights Act, both of them, after exhaustive consultation and inquiry, particularly in the case of the Human Rights Act, Independent Human Rights Act review, gave the courts a pretty clean bill of health. So I think there is some evidence to support what I'm saying, but we must never be complacent. Thank you.
Thank you very much, Lady Hale. And now we're going to turn to Professor Menon to give us the perspective of a political scientist on these questions. Professor Menon.
Thanks, Kate. First, I should say I certainly don't speak on behalf of political scientists. That would be a claim too far. But I suspect I'm here slightly to play a role as a devil's advocate, which I shall do with a degree of trepidation. And I suppose my bottom line is that we shouldn't take things for granted, our beliefs and our assumptions. And we all do it. We all live in our bubbles and echo chambers. And I don't think we should be surprised by the fact that we see a bunch of conservative politicians now arguing that politics should hold the whip hand over judges, and we see judges and lawyers arguing that those conservative politicians are wrong. None of this is particularly surprising, but I mean, insofar as I've got an argument, I suppose it's an argument that lawyers need to think about the assumptions they make and explain their arguments for the role of the courts, perhaps more clearly and forcefully, particularly to non-lawyers, than they have in the past. Because I don't think for many people it's obvious either that judges have a kind of unique authority to which we should defer, or that judges should have a role deciding on things that for many of us feel more political than legal. First, the question of trust. And here I think you can't avoid the question of identity. Judges are overwhelmingly white, Oxbridge and private school educated. They are part of the elite. And of course, politics of late has had an awful lot to say about the elite and how the establishment should be challenged. And for many politicians, there's no reason why judges should be immune from this. From this follows a question, which is why should we assume that judges make decisions that are somehow independent from their own preferences and from their own biases? We're all clouded by our priors, and why is it that we should assume that judges make better decisions than others? And to put it in provocative terms, why should a white Oxbridge educated judge be better at spotting discrimination than a brown female Home Secretary? I mean, there are obvious answers to that question, but I'll post it as a rhetorical one. And secondly, of course, we have politicians to take difficult decisions for us, whether it be on rights or whether it be on policy. And we need to start thinking about the reasons why certain rights or certain aspects of public policy should be enshrined in constitutional or quasi-constitutional form so that they're beyond the reach of our elected representatives. Is there an argument for that being the case? And if so, to which areas of public policy should it apply? And again, that takes us back to the issue of trust. If judges are a liberal elite, why should they have a role in deciding which areas elected politicians should have no say over? I'm not here to make a hard case one way or the other, but I suppose one of the things that strikes me is we spend a lot of time talking to our own peer group, and lawyers spend a lot of time talking to lawyers. What I think we need in the current political circumstance is more of a conversation where lawyers get better at making the arguments for things like judicial review, for things like the role of the courts within the Human Rights Act to non-lawyers, because actually they're the people ultimately that you need to be persuading.
Thanks very much indeed, Professor Menon. So I'm going to pick one of the questions that that you have put to ask the other panels, or perhaps a slight amalgam of the questions you put to ask the other two panelists to respond to it. So that is really why we should have, or why we need judicial review. And in reflecting on that question, what is it about the way in which courts function, which mean that they may be good at answering the questions that are raised in judicial review? Lady Hale, would you like to respond to that first, and then I'll turn to Professor Young?
Well, I'll do my best. Obviously, law is everywhere. Law governs all areas of human activity, including what governments can do. And sometimes governments do things that are unlawful. And there has to be somebody who can tell them that if their actions are challenged. Courts only intervene if somebody brings a challenge. So a lot of unlawful activity probably never goes challenged. And if the question is it lawful or not? Well, then one would expect that judges who are lawyers will be well qualified to decide upon that. And of course, judges have to sit in the open and hear all sides of the question, listen patiently to the arguments, both by the challenger and by the government, and then produce a reasoned decision as to which of them is right. That's how courts operate. And one would have thought that that was a good thing. I quite agree with Professor Menon that the judiciary is not diverse enough. But one of the benefits of having an appeal process is that if you go to the Court of Appeal, it's likely that the case will be decided by 3 judges. And if you go to the Supreme Court, it's likely that it will be decided by at least 5 judges. And that means that the capacity for one individual's take on things, bias, conscious or subconscious preferences ruling the day, really quite slim, because the judges will all think for themselves, of course, but they will argue it through, and they will try and reach a unanimous decision if they can, as to whether what the government has done is within the bounds of the law. So while I would very much welcome a more diverse judiciary, I do think that the appellate process is a way of doing its best to iron out the biases of individual judges.
Thank you. Professor Young, anything you'd like to supplement there?
Yeah, I think what I'd like to focus on is, what are the courts actually doing when they do judicial review? Because I think sometimes it's easy for lawyers to say, oh, something's gone wrong, they've acted unlawfully, we're bringing an action for judicial review. And it isn't necessarily easy to understand what that actually means in practice. And I think the vast bulk of these cases for judicial review are situations where there is a clear legal principle, often set out clearly in legislation, that might set out things like procedures that an administrative body should be following in order to take a decision fairly, or will set out people perhaps you need to consult, or will set out a very clear account of what legal power a particular administrative body has. Now, anybody can make mistakes with their powers, and that's particularly so as the state grows, as you're expecting public bodies to take on so many different functions. And a lot of what judicial review is saying, you didn't follow this particular piece of legislation, or you didn't follow these rules. And a lot of those things get ironed out before you even get to court, because you have ideas of pre-action protocol. We have this idea of the duty of candor, where a public body will exchange information with the applicant. And often what the courts are doing is pointing out, you had this power, here is a very clear law setting out how you're meant to exercise this power, but it didn't work here correctly. And that is the vast bulk of what the courts are doing. I think it's very easy for us in these big debates to point to these very big, important constitutional cases where you have 11 justices of the Supreme Court dealing with something that is very politically controversial, and point to that and say, I'm not sure the court should be playing this role. And I think we have to recognize that's very rare. And I think it's a very distinct role that the court is taking on in these bigger cases, when you have a kind of bigger, almost like a constitutional crisis in a sense, of trying to understand what the limits of power should be in those cases. And I think in those cases, the courts are doing something very different, but equally important, setting a constitutional backstop, which even at the end of the day is not tipping the balance of power in the hands of the courts. So if you look at the two big cases, which we might be discussing further, the big Miller decisions, where you had all 11 Supreme Court justices, you had the Supreme Court saying, no, Parliament needs to do this. It can't be the government alone. So it gave power back to Parliament. And in the second case, a prorogation case, you have the court saying, no, this prorogation was unlawful, again, giving power back to Parliament. And I think it's recognizing that in a lot of these big controversial cases, the courts are actually protecting Parliament, not necessarily themselves. And in most day-to-day cases, the courts are recognizing when a clear legal power has not been implemented properly by an administrative body.
Thanks, Alison. So I'm going to turn to Professor Menon and see if there are still questions in his mind about why we might need judicial review, or if there are things he'd like to respond to.
I suppose, the big question in my mind is something that sort of, I wouldn't pretend to know the answer, is sort of where the balance between politics and law lies, particularly when it's a question of rights. We have a country that is deeply polarized around values issues, which incorporates a division, I think, over rights as well. And there is a perception that, a kind of liberal elite which is out of touch with a large chunk of public opinion basically gets to run the show. And one way they get to run the show is enshrining things as rights, because that makes it harder for a parliamentary majority to address it. And that, I think, regardless of which side of the argument I myself are on, there is an interesting question, isn't there, about how far those rights should extend and why it is that certain things should be entrenched in that way and not other things.
Yes, well, Lady Hale, would you like to respond to that? And I think it will take us directly to the European Convention and to the Human Rights Act and the provisions therein. Would you like to respond to that question?
Well, yes, if we're talking about rights, well then, and rights which are to a limited extent entrenched, well, we must be talking about the Human Rights Act. But the Human Rights Act does not place limits on what Parliament can do at all. It does place limits on what public authorities can do, but if there is an act of Parliament which does something which the courts think is clearly incompatible with human rights, all the court can do is make a declaration stating that fact. And that leaves it entirely up to Parliament whether to do anything about it. There haven't been many such declarations since the Human Rights Act came into force, and all of them have to some extent been acted upon, though one of them was not acted upon by Parliament, and that was the one about prisoners voting, which was the most controversial of all of them. But generally speaking, Parliament has actually put right the incompatibility with human rights, which either the courts or the European Court of Human Rights in Strasbourg had found out. It does seem to me that individuals should have certain rights, which they are able to enforce against public authorities. As I say, they can't enforce them against Parliament, but they can enforce them against public authorities. And these are such things as the right to liberty, the right to a fair trial, the right freedom of speech, freedom of thought and religion, freedom of association, freedom from torture, the right to life. They're really rather fundamental things that I think most of us think individuals should have. It does, of course, get quite complicated because sometimes a government policy does interfere with individuals' rights, but interferes with a large number of individuals' rights. And an individual will challenge it, but basically it's a challenge to a policy, not just to a particular act or omission of a public authority. So there are some examples like that, but that doesn't stop Parliament putting it right if they don't like what the courts have done.
Thank you. And I suppose one other thing one might say about this is that it was indeed Parliament who enacted the Human Rights Act to give courts this very power. And while it was also the UK government who acceded to the European Convention, and until the Human Rights Act came along, if people in Britain were unsatisfied with the way in which they'd been treated in terms of the European Convention, they had to go to Strasbourg to vindicate their rights. So one of the things Human Rights Act did was ensure that British courts could determine these questions. Professor Young, anything you'd like to say about this rights, the question of whether courts should be determining rights cases and what the implications are, as it were, for democracy and also for disagreement, which I think underpins Professor Menon's question, the disagreement that might exist among between people as to how these rights should be vindicated.
I think it's two things I'd like to say just quite quickly. And I think the strongest element of criticism in Professor Menon's argument is I'm not so sure that people know what their rights are, if that makes sense. And so in some senses, there isn't necessarily an ownership of rights. And I think we do need to do more as a society to explain what these rights are and have a conversation about why we have these fundamental human rights, what role they are playing. There can be quite a lot of misinformation as to what human rights are doing in certain circumstances. I think it is really important. So that was one thing that did come out, I think, very clearly from the Independent Human Rights Act view, that there's a real need for education on why we have these rights, what role they play, and just getting people involved in understanding and having their say in what the content of these rights. I think that is missing. I think more needs to be done. Second, I think I'd like to point out that the courts in most of their decisions are quite careful when they are, even when dealing with rights cases, to think about, well, how far can we actually go? And the courts do recognise that some human rights are quite controversial, and it might not necessarily be their role to interfere too strongly or give a very strong and precise account of what the right should be. So one such example is when we're thinking about the right to assisted suicide and whether that should exist, if it should exist, and if so, are the courts just there to point out when that might be problematic, and is it really for Parliament to work out how to implement that on a case-by-case basis if that is what society wants in a particular situation? And courts are also very cautious when dealing with socioeconomic rights. So there's a recent case looking at the child tax credit benefit, where so there's a cap so that you could only have 2 children in a household, and any more than that you didn't get any extra tax credits with regard to the children in the household. And again, the courts are very cautious about saying, well, this is a complex policy choice, and if it's some elements of discrimination, we'll look at it very stringently. But when it's just dealing with slightly fewer or more children in the household, it doesn't have the same amount of stringency. And again, it's quite controversial, and not every individual will agree with that approach, but I think it does show that the courts don't intervene too strongly if they're dealing with these complex socioeconomic choices, because they recognise Parliament has a role there.
Thanks very much, Professor Young. Anything further you'd like to say about this, Professor Menon? I think we could always talk a lot about rights enforcement and how to draw the line. But I would like to turn to one other thing before we turn to the really interesting array of questions that are popping up in the Q&A. And that is to look a little bit more closely at one of the decisions that I think led to some of the controversies about the role of courts, and that is the second Miller decision about the prorogation of Parliament and the question of whether courts could determine the extent of the prerogative power at all. And I wonder, Lady Hale, if you might like to talk a little bit about that, about the decision and what it really means from a point of view of the extent to which courts were reviewing the prerogative power at all.
Well, it has for centuries been part of the role of the courts to determine the existence and extent of the remaining royal prerogative. Royal prerogative is the residue of powers of the Crown which have not been limited or taken away by Parliament. And of course, they are now exercised by the government in effect. And the courts have been examining the limits of those powers for centuries. We weren't in the Supreme Court doing anything particularly new in that respect. I think the circumstances were quite unprecedented. In modern times, it had not been attempted to suspend the role of Parliament for so long at such a crucial time in the nation's history. So the circumstances were exceptional, but the role that we were being asked to play was not. And of course, we had no choice in the matter. I don't know if everybody remembers that there was a case brought in England by Mrs. Miller challenging the Prime Minister's advice to Her Majesty that Parliament should be prorogued. But there was also a case brought in Scotland by Miss Joanne Cherry MP, QC MP, and more than 70 other people also challenging that advice. And the English court came to the conclusion that this was not something that the courts could look at. And the Scottish court came to the conclusion that it was indeed something that it was the court's job to investigate, and also came to the conclusion that what had been done was unlawful and of no effect. They couldn't both be right. There's only one UK Parliament, and it either had or had not been effectively prorogued. So the Supreme Court had no choice but to take the case, and no choice but to make up its mind between those two opposing points of view. And as it so happened, we did agree that the outcome which the Scottish courts had reached was the correct outcome, for not precisely the same reasons as the Scots had reached it, but not far off. Although it was a highly politically charged situation, none of the arguments that were presented to us were political arguments. They were all about the extent of the power to prorogue. That's what they were all about. And of course, looming very large in those arguments was the sovereignty of Parliament. Parliament is the fount of all of our laws, and it needed to do rather a lot of jobs before what was then scheduled to be the automatic exit day. And so to suspend Parliament so that it couldn't do all of those jobs during that time did seem to the whole court to be way outside the limits of the power to prorogue Parliament, way outside it. I've often wondered what might have happened had we been presented with more evidence from the government, and particularly from number 10, as to what had motivated the decision and what the political arguments were for doing it. And we could all make a guess at them, obviously, but we had no evidence whatsoever. We had no evidence of any reasoning leading to such a long suspension of Parliament. quite what we would have done if we'd had such evidence, I wouldn't like to speculate.
Probably would have turned on the evidence itself. And the fact of the absence of it does show one of the roles of a court in these kind of circumstances, which is in a sense to be a facilitator of accountability and transparency to not only you would have heard, but the whole country would have heard, which would have been part of the political process itself. Professor Young, anything you'd like to say about that decision?
Not really. I said everything that there is. The only thing is to reinforce that the prorogation of Parliament, I mean, in some senses, this was unusual as well because it was announced beforehand. So it actually allowed people to be able to bring these court cases. But normally, Parliament doesn't get a say in prorogation at all. And so I think you're faced in a very odd situation where not only is the court having to think very carefully about the legality of the decision, but it's also thinking about it against a backdrop where you're protecting the sovereignty of Parliament in a situation where Parliament normally wouldn't really have a say in this. And so I think it's understanding that angle to it as well that is important.
Thanks very much. And I think that brings us to one of the first questions that's been put, because it's really a question addressed to you, Lady Hale, which is whether Her Majesty the Queen is subject to law. And this brings us back in some ways to the question of prerogative power and so on. But would you like to respond to that question?
Well, the way in which I would respond to it is that when we were deciding the case, we did so on the assumption that the Queen herself had had no choice but to accept the advice of the Prime Minister. There is quite a lively debate, particularly elsewhere in the Commonwealth, where there is still a monarchy and therefore a Governor-General, as to whether indeed there are certain things that the monarch or the monarch's representative can do or refuse to do. But nobody suggested to us, it wasn't part of anybody's argument, that the Queen herself had a choice. It was taken for granted that if her Prime Minister advised her that this is what she should do, she had to do it. And so that's why the whole case revolved around the advice which the Prime Minister had given to Her Majesty. No doubt there might be, at some future date, some case which did raise directly what Her Majesty could do, but I doubt if that would arise under the present monarch, because I think she will take a great deal of care not to exercise choice in circumstances where it's controversial whether she can exercise choice. Who can say what would happen in the future? I know not.
Well, thank you very much. Would any of the other panelists like to comment on that question, or shall we move on to another question? Right, so the next question is whether you think, the panelists think, that there's been a decline in the constitutional balance that Professor Young spoke about and institutional cooperation between the different branches of government in the years since the effective disappearance of the constitutional role of the Lord Chancellor, the previous role of the Lord Chancellor. Has that affected this constitutional balance about which Professor Young spoke? Perhaps you might like to respond to that initially, Professor Young.
Thank you. I think it's an interesting question because obviously we modified the role of the Lord Chancellor in the hope of trying to promote constitutional principles by promoting the separation of powers and making sure there wasn't an individual who somehow had a role in all three branches. But I think in some ways what that has led to is, particularly because of the way in which the appointment to the role of Lord Chancellor has become more of a typical political ministerial appointment, even though it's meant to be somebody who has this special role to promote the rule of law. And we've seen some kind of elements of sort of shifting in Lord Chancellors, often perhaps not necessarily when you expected it, coming through as well. And that might in some senses have meant that there isn't the same informal discussion going on in the background to understand how the role works. Whether there is an element of cause and effect because of that, I think is much harder to set out. I think it's due to a whole different range of factors. I think a lot of this depends on, do we have important constitutional things going on in the background? So I think you can't divorce what's been going on from the constitutional elements of Brexit and how the constitution works post-Brexit. I think it's had quite a lot of shock waves that I think has then triggered on all sorts of other different factors. So I don't think there's necessarily cause and effect, but I do think in some way we need to think about how we rebuild those informal mechanisms of really reinforcing that there is an importance of the rule of law within government, as well as having conversations between the judiciary and government to keep having this element of understanding and respecting different constitutional roles.
Thanks very much, Professor Young. Professor Menon, do you want to comment on this change in the institutional character of the Lord Chancellor?
I know my limitations well enough not to get involved in a discussion of the role of the Lord Chancellor. What I would say, though, is the question was quite interesting in that it spoke about a decline of the constitutional balance. There's been a shift in the constitutional balance. Whether you see that as a good thing, as a bad thing, as a decline, or something else is going to depend on your point of view. I think language actually matters quite a lot when we're talking about these things in that sense. But I'll leave it to the experts to talk about the Lord Chancellor, which Alison has just done. Thanks
very much. Lady Hale?
Well, the only thing that I would add to what Professor Young has said is that there's a very famous and knowledgeable and learned professor of law at Yale, who certainly holds the view that the change in the role of the Lord Chancellor has had an impact on the government's understanding of the rule of law, because the Lord Chancellor is no longer a very senior lawyer who has very senior precedence in cabinet and was there to tell cabinet, well, look, you may think this is a good idea, but I have to tell you it's got the following legal problems to it. In the olden days, the Lord Chancellor was a person of such stature that people tended to listen. Now, I find it quite ironic, because I think only in a country like the United Kingdom, which is full of paradoxes and constitutional contradictions, could it be said that having the head of the judiciary as a senior member of the government was actually a protection for the rule of law rather than the reverse? Because obviously in normal constitutions, the head of the judiciary is completely separate from both government and parliament. But it's a typically British thing, is it not, that might just possibly have been the case, even though in constitutional principle it sounds all wrong.
Yeah, I mean, it points to, doesn't it, that political culture is a very important part of a living constitution, and one can't only just look at the legal rules and conventions, but also one needs to look at political culture, and it's often very difficult to predict how they will interact when you change things. The next question is a question about whether our understanding of the rule of law is determined by what we think law is. The question is, actually, do we believe our conception of the rule of law, of legality, depends on prior conceptions of law? And whether it could be said that the British constitutional tradition helps us to see a fundamental connection between the rule of law and the very concept of law. In other words, the connection between the rule of law and what we think law is. Professor Young, would you like to respond to that?
I'll try my best. That's going to require a degree in philosophy and jurisprudence to try and pick up on. I'll see how I can deal with it. I think often when we're thinking about different conceptions of law, there's different ways of trying to think about what law is, and that can then filter into our understandings of the rule of law. So there are some arguments that law and politics really aren't all that different at all. And so if we see law as very similar to politics and very similar to political arguments, then it's easy to then say, well, I'm not really sure the rule of law should be doing much beyond just pointing out when very clear wording in legislation tells us that a particular public body has acted incorrectly, because otherwise what the courts will be doing is making political choices. There are other conceptions of law that might say, well, actually, we're thinking about law as being very close to morality. And so if law is only law if it's morally right, then if the judges are very good at making these decisions of moral reasoning filtered through the law in some senses, then we need to have a very strong protection of the rule of law. So I can see these connections. I think these are very divergent poles, and the truth is very much in the middle. And that's why it's so difficult for us to work out how the balance works in practice. I think what we need to understand what the courts are doing when they're talking about protecting the rule of law is they're not sitting there saying, this is what I think is politically the right answer, and this is then law and I'm protecting it. Nor are the judiciary saying, here am I in my lovely Supreme Court ivory tower, reasoning grand moral thoughts and principles and coming up with what is the morally right answer that has definitely got to be reinforced. Courts are looking at past decisions, past legal principles that filter through a whole set of previous decisions and previous accounts. And from that, so it's building on what these principles might be. So as Lady Hale was mentioning in Miller 2, there is a very, very long line of cases going right back to the 17th century, telling you that the common law sets limits on prerogative power and building on this idea of using parliamentary accountability and parliamentary sovereignty to set those limits. And if you have that understanding of what a law is, this building incrementally on these principles that not only come through the case law, but can also be corrected by Parliament if they don't like them, then I think it's easy to defend the role of the court in protecting the rule of law. So that's my best jurisprudence in a snapshot I can do, I think, to try and set the stage of how they are interconnected.
Thanks, Professor Young. Lady Hale, would you like to respond?
Forgive me. Well, I don't think I could add anything really serious to what Professor Young has said. As far as a judge is concerned, law consists either of legislation, that is, acts of Parliament, or rules and regulations made under powers given by acts of Parliament. And what the court is doing when it's enforcing the rule of law is interpreting that legislation. There are, of course, various principles of statutory interpretation, many of them laid down by Parliament, but some of them devised by the courts, which dictate how one reads legislation. But that's what we're doing. And there is also the judge-made law, that is the law that's been built up, as Professor Young was saying, out of the decisions of the court over a very long period, although it does develop from time to time. And one is always trying to build upon the principles that have been devised in the earlier cases in order to find the answer to a new problem that has arisen. So that's what we think the law is. We don't think that it's necessarily laying down standards of morality. Sometimes it does and sometimes it doesn't. We don't think it's making political choices. Sometimes it is and sometimes it isn't. What it is doing is making rules.
Thank you. Professor Menon, do you want to say anything about the rule of law and law itself?
Yeah, I'm going to tiptoe very carefully around this question that I don't really understand. But what I would say is I don't think we should kid ourselves. Of course, courts take political decisions. I mean, they might take them on the basis of a reading of the law for legal reasons. But it strikes me that saying that courts don't take political decisions is a bit like economists saying central banks set interest rate policy in the interests of everyone and it's optimal for everyone. That's clearly a nonsense. They take their decisions on the basis of very careful consideration of their own expert field, you know, the macroeconomy on one hand and the letter of the law on the other. But I think it is really dangerous to try and convince ourselves that this is somehow discrete from the realm of politics. Baroness Hale said earlier, the law is everywhere. Well, politics is everywhere too. Politics intrudes on everything. And, you know, whether it's for the best reasons or the worst reasons, judges are doing things that are inherently political.
So do you mean by that, sorry, do you want to go ahead, Lady Hale? Or?
Sorry for coughing earlier. all I wanted to say was that I don't think I've ever said that judges don't make decisions that have political consequences, or in fact decide questions which are the same questions that politicians are deciding. What I would say is that judges make decisions for legal reasons. They don't make them for political reasons. The reasoning that leads to the decision is a different sort of reasoning, even though the effect may be a political effect.
And of course, those reasons are in the judgment. So one can assess them according to whether you think that they make sense or not. Professor Menon is not looking entirely persuaded, but I think we're going to move on. Sorry.
Go on. I mean, it's not that I'm not entirely persuaded. It's just I had a sort of the follow-up question was, I suppose, are elected judges less reliable than non-elected judges? Because it seems, there's an issue here. If, over the pond, there are violent political fights over the election of judges, which seems to me to suggest that there's something else going on here apart from a reading of the law, in which case, where does one draw those lines? I mean, these things shade at the margins, don't they?
They do. Should we? I think it isn't.
We can leave that for another day.
Well, the way in which judges are appointed is very important. Some judges in the United States, in states, are elected literally by election on a ballot. Federal judges in the United States, including the judges of the United States Supreme Court, are actually appointed. They're appointed in a particular way, nominated by the president and then confirmed by Senate. But that it's not actually elections. But I think that the underlying point is that we do expect judges to be independent, and what does the mechanism of appointment mean for that independence? Perhaps that is something worth exploring. Professor Young, do you want to talk a little bit about mechanisms of appointment and judicial independence?
Okay, well, we now have a system of using so there's an appointment process through an independent panel, which is looking predominantly at ensuring we appoint members of the judiciary on merit. So that is the whole basis on which we are trying to appoint the judiciary. And we do have within legislation a statement that we are protecting the independence of the judiciary, and that is an important aspect of the UK system to have an independent judiciary. I think when you're comparing and contrasting with what we do in the US, you have to recognize that the US has a complete different constitutional structure. So it has a federal structure, it has a presidential system, not a parliamentary system. And of course, it has this little codified constitution that sort of gets in the way and gives rights and empowers the judiciary to strike down legislation that breaches its principles. But it's an old constitution, and I don't mean that pejoratively. It tends to have very, very broad rights in there. And a lot of the work that is done is defining the right. So I've done some work in the past on comparative freedom of expression. And whilst in the US, you don't make laws that restrict freedom of expression. And so the big question is, well, what is freedom of expression? And that can be very difficult when you have very little information in the text to help you. Transfer that across to the UK and the ECHR, and you have a right to freedom of expression, but it can be restricted in certain circumstances for these legitimate purposes, provided it's proportionate. And so there's more guidance as to what the speech is there for and how we balance it. And so I think I don't want to move to a political judiciary. I don't think we need a system where we elect the judges. I think independence is crucially important to give a check in our constitution, which is very different from the US constitution.
Thanks, Professor Young. Lady Hale, anything you'd like to say about the appointment of judges?
Not particularly, except that the great RBG, Ruth Bader Ginsburg, when asked what was the best way of appointing judges, she said, well, one thing for sure, it's not to elect them.
Yes, thank you. There is one question that's just followed up, come in recently, Professor Menon, on your point about politics. And the question really is whether you are distinguishing between what might be described as big and small p politics, big P being party politics, I think, and small p being value-laden and political decisions. Or do you, when you make the comment that that all decisions court make have some political are political in some sense? Are you employing a conception of politics which is not really party politics, but more about value laden and political in their impact?
God, I have to say these questions are making me delighted I'm not a lawyer, because they're all quite tricky, aren't they? I have to say, small p, I mean, if politics is the sort of authoritative allocation of resources, okay, if you go back to first principles, then that's small p politics. I mean, it's a challenging question as to where small p merges into big P, because big P seems to intrude on everything these days. But when I was talking a minute ago, it was the P was small, I think.
Fair enough, thank you. And I think that's helpful to clarify, because as you say, this is a difficult line to draw, but it is one that we realize that somewhere there's a continuum here where some are on one end and others on the other. Yeah. So there's another question that's come in which refers to the notorious Daily Mail headline, "Enemies of the People," after the Court of Appeal had handed down its first Miller decision, which we haven't talked about at full length here, but was just wondering whether, in the light of newspapers making those kind of comments about courts, whether in fact politicians wouldn't be the best people, best equipped to persuade the public of the merits of the rule of law rather than judges. Professor Young, or maybe Professor Menon, would you like to say something about that?
I mean, I think one of my suggestions is that lawyers need to act more like politicians. I mean, I started off my remarks by talking about speaking to our own bubbles. And I think if you've got a government whose bubble is the population and lawyers whose bubbles are the seminar room, it's a fairly unequal battle. So I think, we seem to me to be in a political era where some of the fundamental aspects of our system are up for debate in a way they haven't been for quite a while. And I think, there's no point turning up at a gunfight armed with a knife, as it were. And in that sense, I think we all need to become better at talking to audiences we're not used to talking to. I mean, I take the point about the tabloid press, and I take the point about the sort of unpleasant headlines that they come out with. But I think, this is a fight. It's a fight for the system of our country. And I think it needs to be carried out in public, because ultimately, in the era we're in, a reference to the public is central to everything that goes on. This is why, our last election in 2019 was a choice between two populist alternatives. Corbynite populism versus Johnsonite populism. That isn't going to disappear. And I think in those circumstances, simply winning the battle in the seminar room is no longer enough.
And I presume when you talk about politicians there, you mean small p rather than big P.
Oh, good Lord. Yes.
Professor Young, Lady Hale, anything you'd like to say about that?
Very little to add, really. I think just to reinforce, I think it really is important that discussions are in public. I mean, one of the good things, if there was a good thing to the headline, was it got people talking about this. So it got people thinking about why was there this criticism? Why did a newspaper come out and think the judiciary were enemies of the people? And I think also one of the other really good things that came out of the Miller decisions was they were broadcast, so anybody could go away and watch the proceedings. And I think that did a really good job of showing people what the court was actually doing, and made it very, very clear, particularly in the first Miller decision after the Enemies of the People headline, that you didn't have Lady Hale and her fellow justices of the Supreme Court talking about, are you pro or anti-Brexit? You had them talking about very complex legal issues, about the scope of prerogative powers. You could see huge bundles of materials in front of them and laptops that they were using for the law. And I think that did a really good job of educating people of what the judiciary were actually doing. And I think in that sense, I think that was very important, and long may those discussions continue.
I mean, can I just add a couple of things to that? I mean, the first is that Alison and Mark ought to be congratulated for this project, because this project is doing exactly what I'm saying that lawyers ought to be doing, which is talking more broadly. The second thing is, I mean, I agree with what Alison just said. It just strikes me that one of the troubling features of where we are now is the partisan split that exists around these issues. I mean, if you go back to Miller 2, I think 47% said it was a fair ruling, and they split very much along leave remain lines. And this is just, this is a fact of the country we're in at the moment, and it's something we need to take very, very seriously, that people do, rightly or wrongly, believe that these things are coloured by your Brexit preferences. And I don't have the answer to that, but it is a very worrying development now that so many fewer Conservative voters were happy with the judgment than Labour voters, which was at the time a leave remain split. Yeah.
Another question has come in which relates to this, and which I think Lady Hale might like to respond to, which is in a response, in a sense, to Professor Menon's suggestion that judges ought to be more in the public domain, talking about the role of courts and the role of law. How is this limited or made more difficult by judicial independence and other particular characteristics of being a judge? And in a sense, does this make it more difficult for judges in particular to speak out about, and even in a relatively explanatory way, about the role that courts play within the Constitution and why that role is appropriate?
I don't think in recent years there has been any problem about judges, if they want to, giving explanatory talks to all manner of audiences, explaining what they do, what the courts do, what the law's all about, and so on and so forth. And some of us have spent a lot of our time doing that sort of thing to all sorts of audiences. And it's definitely regarded as part of the job of a Supreme Court justice. So I don't think that is a threat to independence. Obviously, if the courts started talking about judges started talking about their views about the merits or lack of merit of any particular political platform or political decision, that would not be a good thing, and one shouldn't do that. But I don't think it's too difficult. That's not too difficult a line to draw.
Thank you. And I think there has been a change in judicial culture in many parts of the world, as judges being more willing to speak in public spaces. So the next question I wanted to turn to is a question about the unwritten nature of the UK Constitution and its fluidity as a result, and whether that means that there's a danger that the Constitution is vulnerable to the courts, is how the question is put, because it's unwritten. Professor Young?
Thank you. I can see why there's kind of two ways of dealing with this. In some ways, the uncodified Constitution does give an element of flexibility. It does allow an aspect of institutions to play a role in the development of constitutional principles. I think it can leave it vulnerable to either, the danger of the Supreme Court deciding, well, here are a whole lot of constitutional principles that we have found in a common law cupboard. They don't necessarily have a long pedigree, and we're just going to tell you this is what they are, and there's no public debate on whether we want to have those constitutional principles. And there's also a danger on the other side that you can have the element of any government of whatever political persuasion, if they have a large majority in Parliament, can radically modify the Constitution. And much as you can say, well, at least there's some accountability from the people, I'm not sure how far the people who vote for a particular political party fully understand the constitutional consequences of any changes or even aware of them. So my favourite is the Dissolution and Calling of Parliament bill. If you've no idea what that means, go away and look it up and see what you think about it, because I don't think people are aware that that constitutional choice is necessarily going through at the moment. So there's vulnerabilities on both sides. The aim, the hope is that by this uncodified Constitution can modify by having the input from both institutions, so both get a say in modifying the principles. Where I think what gets left out a lot of the time, which is partly what motivated Professor Hale and I to think about this project, is getting the people actually involved in understanding what is going on and having an awareness and a say in how those constitutional principles develop.
Thanks very much. Would either of the other panelists like to comment on this question? Lady Hale?
Am I unmuted? I think I am. Yes, yes. Well, I've found Professor Young's answer extremely interesting. I think I'd like to add that there is a problem, obviously, with the Westminster model of democracy, which doesn't separate government from parliament. And it means that the government is chosen from the political party and its leader in particular, who can command a majority in the House of Commons. And this means that the government in practice can usually get the legislation that it wants through Parliament without, sometimes with trouble, but without too much trouble. And it means that it dictates the agenda of Parliament. It decides what business Parliament will discuss and what business it won't discuss. And there's lots of other things that the government can do. And this means that in order to have any sort of constitutional limits, other than those which result from the law, there is a need for checks and balances, conventions, ways of doing things, what Peter Hennessy calls the good chaps theory of government, which are an important part of the constitutional balance. And with an unwritten constitution on the Westminster model, those things can fairly easily be set aside or not have the power that they should have to enable a properly balanced constitution.
Professor Menon, would you like to say something about this?
I think there's anything really to, I mean, what I would say is there's a vulnerability both ways, isn't there? As I think Alison said. I mean, it makes the Constitution very vulnerable to politics as well. I mean, precisely because, as Lady Hale was saying, because of this good chap theory of politics, is, you know, there is an open question as to whether this sort of very fluid and sophisticated system we have works in all kinds of political culture or not.
I mean, I suppose as somebody who comes from a system with a written constitution, I'm quite influenced by Professor John Gardner's piece about whether a written constitution is ever possible. Even written constitutions have these fluidities and flexibilities within them. And I think one of the things we're looking at globally as we see an increasing and worrying pattern in democratic decay. Freedom House, for example, shows we're in the 15th year of a sort of decline in democracy around the world, is that this happens in all sorts of constitution settings. And so it's that I think even in written constitutions, one can overestimate the extent to which the language of the constitution can constrain against political decay. Not to say that it doesn't to some extent, but it's perhaps, we perhaps sometimes think it does it more than perhaps it does in fact. We're running out of time for the questions, and they're a really wonderful group of questions. Thanks so much to those of you who've attended and put them in the chat. There's one that I want to put to our panelists, and that relates to very much the relationship again between the branches of government and particularly the relationship between the courts and the government and the legislature. And that is the suggestion by the current Justice Secretary that the executive should have the power to override judicial decisions, whether by definition it's inappropriate for the executive, the government, rather than Parliament. Lady Hale's already described how, in relation to the Human Rights Act, for example, it's clear that Parliament is not overridden by decisions of the courts. But do we feel differently about a proposition that the executive should have the power to override a decision of the courts? Professor Young?
I do feel very differently, and I don't like the idea that the executive alone, unchecked, can decide to override a decision of the court if it's just doing that because it doesn't agree with it. Now, we do have some examples of legislation that did empower the government in certain circumstances to issue so this is a famous case called Evans, which we'll be discussing in the on the website, which did empower a minister, but that's Parliament giving that particular power. And that was it was checked by judicial review, and it wasn't meant to be just because you disagreed with the outcome in those particular circumstances. So I would be concerned, because I think it's quite a dangerous precedent. You have the rule of law. We have this idea that you adhere to legal decisions. If you have parliamentary sovereignty, it's a very different point for Parliament to then go away, debate openly, publicly, and legislate. If this is just the government with no real political checks, and perhaps not even an awareness of the public that this is going on, then I'd be very worried.
Thanks, Professor Young. Professor Menon?
I agree with that, though it does take us back to what Lady Hale was saying, in that the lack of separation. If a government's got an 80-seat majority, in general, you'd count on it being able to get whatever it wants through. And we shouldn't assume, as the Trade and Cooperation Agreement showed us, that just because Parliament votes on something, that it's properly discussed and debated in detail, because there are ways around those provisions as well. So, you know, in a sense, the government under our system usually will have that power anyway, by virtue of the majority it has, which actually, when you say it out loud, is quite scary in some ways.
Thank you. And the last word on this to Lady Hale.
Well, of course, Professor Menon may in practice be right for the reasons that we've agreed upon, but it would be the most fundamental attack on the two basic principles of our Constitution if the executive were able to override judicial decisions just because they didn't like them, and without having a much more specific power from Parliament so to do. It would undermine both the power of Parliament and the rule of law, and it would be extremely worrying.
Thank you very much, Lady Hale. And it's now my turn to thank all our panelists for addressing a very wide array of fascinating questions from our audience, and for, I think, very clearly outlining their arguments. This is an important exercise in trying to understand what a constitution means and how a constitution works, an important question for all of us. So a final thanks to Constitutional Law Matters at the University of Cambridge Faculty of Law for fostering this conversation. I think I found it really very interesting and illuminating to hear what our panelists have had to say. So all of those, thanks very much to all of you who have attended. Thanks very much for being here. And a final thanks to our panelists. Keep well and stay safe. Good night.